Hi, I'm Ben Holden, Director of the Reynolds Center for Courts and Media. The late Supreme Court Justice Louis Brandeis observed in a 1913 Harper's Magazine article that sunlight is said to be the best of disinfectants. What Justice Brandeis meant is that government operates most cleanly when it operates in the open. It's the job of the journalist, including student journalists, to hold government accountable to its promise of openness and to sound the alarm when that openness and that promise goes unkept. The United States government spends more than $970 billion a year on education, one of the single biggest components of government spending. That's almost 30% more than what our country spends on military defense. Student journalists have a unique vantage point as embedded journalists inside the education system to detect where programs might be wasteful or ineffective, and the law provides them with tools to verify how well education dollars are being spent. Colleges and universities are powerful institutions, of course, but citizens hold a great equalizer: sunshine laws. These laws, the Federal Freedom of Information Act and the Open Records and Open Meetings laws that are on the books of every single state, entitle the public to know how decisions are being made and who's making them. Even at a private institution, there's quite a bit of information, such as the type and frequency of crime on campus, that legally must be disclosed. There's no substitute for a reporter doing shoe-leather, door-knocking journalism that makes stories come to life, but knowing where to get public records and what to ask for can supercharge your reporting and help shine that cleansing light of sunlight into the dark corners where secrets like to hide. Here to tell us more about the Freedom of Information Act and a journalist's right to access is Frank LoMonte, Executive Director of the Student Press Law Center.
Let's say that you get a tip in your newsroom that there's money missing from the college foundation. Money that donors contributed to support the educational work of the university is gone, can't be accounted for, can't be found, might have been stolen. This is the time that you need to activate your knowledge of public disclosure laws. Even if your school isn't talking, even if your school isn't returning calls, there may be other ways that you can get at that story and get the information you need to break the news, but it requires a little bit of knowledge about what to ask for, where to look, and then what to do with those records when you get them. That's what we're here to talk about. We're talking about public records laws and public meetings laws and your right as a journalist and as a citizen to get information out of government agencies. When you're working for the student media, let's face it, you have a lot of obstacles to overcome. You're probably the last phone call that people return. You already don't get a lot of respect because your paper has a funny name like the Weekly Anteater, right? And every once in a while, you have to actually leave the newsroom and go to class. Those are all bad factors, but you have one factor in your favor. If you're covering a government agency, especially a public college or a university, you've got disclosure laws on your side. Those disclosure laws are like journalistic judo. They are an equalizer. They're a way that a small, weak person can make a big, powerful person comply. Journalistic judo because they allow you as a requester to make your institution give you the information that they may not want to give you. They're a great equalizer. The laws, they're not perfect. They've got loopholes. They've got exemptions. And people do play games with them, and they sometimes defy them altogether. But we're going to talk about first, what does the law entitle you to? And then second, what to do about it if people won't give you what you're entitled to. Let's start by talking about access to public records. When we talk about mandatory disclosure laws, we're almost always, but not always, talking about public and not private colleges. Later on, we'll talk about some ways in which the federal law, especially when it comes to campus crime and campus safety, entitles you to information even if your college is private and not subject to state disclosure laws. But for a minute, let's focus on the public institutions. Hopefully everybody knows, hopefully everybody's aware that the federal government and every state has a sunshine law that's called either the Freedom of Information Act or the Public Records Act or the Public Disclosure Act, some formulation of that. And they all work pretty much the same way, which is you as a citizen have a right to the information that is used or kept by government agencies unless they can point to a specific exemption in the law that entitles them to withhold it. And let's be clear about where the burden lies here. The burden lies on the government agency to justify denying a request and not on you to furnish a reason for wanting the information. Be clear on that because some agencies will play that game. They'll try to ask you to justify why you want the information and what you're going to do with it. And the answer is, I'm just curious, is a perfectly good reason. You do not need to justify why you want the information. The law places the burden on them to show why you cannot have it. And that's not our policy is not a good enough answer. Policy can't trump state law. It can't override state law. If the policy of the agency is not to give out a document, that's too bad because the legislature has already made that decision for them. Now, when people think about records, they normally think about pieces of paper. But remember that record is defined in the broadest possible way to include anything that memorializes information in any form. That can be videotapes, audio tapes, emails, rich source of information there, 911 recordings by your police department, even the tapes in the video security cameras around campus that you may not even know are there. All of those things are records because they record information. Now, the key to being a great public records digger, the key to being a successful public relations Jedi journalist is that you have to know how government works. You got to know what agencies do what kinds of information they keep, and what they call those records. It's real helpful to be able to know what the name of the document is, but it's not essential. Okay? The people who do the best public records journalism are the people who've spent and invested a little bit of the upfront time in knowing the structure of government agencies. And importantly, right, at a state institution, that includes the hierarchy of government agencies that your institution is a part of, because there may be another agency of government. There may be another level of government that is more forthcoming with their information than your own school is. Always remember those alternatives. If you put in that work in advance, if you do a little of the advanced homework, you'll be amazed at the kind of stories that public records can reveal to you. And they're not the dry and dusty stories either. For instance, right? Everybody's read one of those stories about how rock bands have these way out crazy demands where my dressing room has got to be stocked with exactly the right fluffy towels and exactly the right number of bottles of Chardonnay and exactly the right color bowl of M&Ms, right? How do you think the journalists got that? How do you think the journalists found that out? They found it out because at a public institution, if the government is paying for that band to come and play at that university, then that contract is a public document, and they can't withhold it even if they want to. Let's talk for a second about the mechanics of making a public records request. There are no magic spells or incantations here. There's no formality required. It's best if you're dealing with an agency that has a history of trouble, or it's one that you're not familiar with, or maybe it's far away, to deal with them in writing. If it's a local agency, especially when you have some comfort level with, sometimes it's a good idea to start out with that verbal request. Sometimes it's a good idea to start out with that phone call. It could be disarming, it could be a little more relaxing. If you start to get pushback, if you start to get resistance, then start communicating in writing, because that's going to give you the paper trail that you might eventually need in the unlikely event that you've got to appeal a public records denial to the courts. Build and save that paper trail. You also want to remember that public records are exactly what they sound like. They're public records. And people will get all huffy and indignant sometimes and say, that's public information, that's public information. But the law doesn't apply to information, it applies to records. And that is an important distinction, because under most state laws, you can't force the agency to go out and do your research for you. You can't force them to do your homework for you. If you go to the Board of Regents and you say, I want you to compile for me an alphabetized list of all of the highest paid medical professors in the state, from highest salary to lowest salary, they're not obligated to go out and create that spreadsheet for you unless they already have it. If they already have it, then it's yours. Then it is yours. The normal rule is that anything that is used, maintained, kept, generated by a government agency is a public document. It's available not just for you to look at, but for you to make and keep copies of. Now, every Public Records Act has its exemptions, but don't start by assuming that the documents are exempt. Make the agency justify the exemption. There are some common exemptions that you'll probably run into if you do a lot of public records requests. Big ones are things like attorney-client communications. If the agency is sending memos back and forth to their lawyer about an ongoing lawsuit, excellent chance that's not a public record. Same thing with some, but not all, personnel records. Again, don't assume that there is a blanket personnel exception. There's some boilerplate information, things like the employee's salary, things like the employee's travel, things like the expenses that the employee has been reimbursed for, that are boilerplate public information that you're entitled to, so don't assume that they're exempt just because they relate to personnel. A couple of years back, some college journalists at the University of Wisconsin at Milwaukee did a terrific series of stories called Tarnished Badge. And this series focused on the local police department and the backgrounds of the officers. And what they were able to do using public records was to build a portrayal of a police department where many of the officers had fairly serious criminal histories that had been overcome by a program called deferred prosecution, where they were not adjudicated guilty of the crime and allowed to keep their badges. And it raised real questions about whether this deferred prosecution program was being abused in favor of police officers. And the way these journalists were able to build their case was through public records, including not just criminal records, not just court records, but even the personnel files of the police officers. So don't assume you can't get sensitive personal information. You may surprise yourself. If you make a request for public records and you get zero back, you get absolutely zero documents back, don't give up. It's almost never the right answer that you're entitled to nothing. If the agency is able to segregate out the public parts of the documents and black out the private portions of the documents, then they're supposed to do that. If they produce zero, then it's probably time to pick up the phone, get in your car, and start negotiating, because you can almost always get to something that's at least halfway to where you need to be. If you get a denial letter, think about whether there's something less than 100% of your request that still might get you the story. For example, let's say you're doing a story about discipline against fraternities on your campus. Well, it's very likely that the school will not give you individual disciplinary write-ups against named individual students showing you what they were punished for. But that might be okay. You probably weren't going to publish that anyway. Maybe it's good enough for you to get the records with the names and the other personal identifiers blacked out. Maybe it's even enough for you to just get them fraternity by fraternity because you're looking for patterns and trends. So think about whether you can haggle your way to something that's less than all but still gets you the story. And use that same approach if you get some outlandishly high financial bill for those records. We've seen this more and more, that people are being charged thousands of dollars for search and duplication of public records. Go into used car buyer mode at that point, okay? That first price you get is the sticker price, and only a chump pays sticker price. Start haggling and ask to see a breakout of the bill and see what you're actually being charged for. You might be able to disqualify some of those expenses. For example, if they're charging you some rate for a high-priced lawyer to spend hours going through and blacking out the documents, that's probably not allowed by law. They're supposed to charge you for a low-priced secretary or clerk to retrieve these documents at most. So ask to see the breakout just like you would if you were fixing or buying a car. Does anybody have any questions at this point? Yes, go ahead.
So what am I entitled to get from the campus police department?
When it comes to freedom of information, The number one conflict between student journalists and their campuses is over police and public safety records. And it's really kind of crazy because it's one of the only times when you have both a state and a federal law that entitles you to access. Nevertheless, it's always a source of conflict and controversy, and it's important to understand what the law entitles you to. Start with the federal law. There is a federal disclosure law that's called the Gene Cleary Act. And remember we said there were some disclosure laws that were good equally against private and public colleges, and this is one. If your college takes one dime of federal money, and almost all of them do, then it must comply with the disclosure provisions of the Gene Cleary Act. And for your purpose as a journalist, here are the important things to know about Cleary. Number one, the police or public safety department have to keep a running, up-to-date, and accurate log of all of the serious crimes reported to them, and they have to make it available on a rolling 48-hour basis during business hours. If you show up on Thursday afternoon, that log should show all the crimes they have dealt with up to Tuesday afternoon. They've got to produce that upon request to any citizen, not just a journalist. It's not going to give you all the detail you need. It'll give you the basics. It'll give you the what, the when, and the where. It'll say something like, car burglarized, student union parking lot, 11 p.m. Saturday, and that's about it. But that's a start. That lets you at least look for trends, look for patterns, and start asking more questions. Second thing that the Cleary Act requires for your purposes is every October there is an annual inventory of all of the reportable crimes on campus that have to be disclosed, not just upon request, but have to be circulated to the campus community. Many of these are now online. That report is due every October for the preceding year, so it's not 100% up to date, but again, it's a starting point for your reporting to look for trends and patterns. But if you're at a public institution, you have rights beyond the Cleary Act where you can get much more information. Under almost every state's law, you are entitled, as a matter of state public records law, to see what's called the incident report that's generated by a police agency. And that incident report, that's your bread and butter as a police reporter, because that's got the police officer's narrative of what he saw, who he talked to, and what he did. That's the bread and butter of the police beat. You want to get those incident reports if you can, and at a public institution, almost every state requires that they be turned over upon request. Not just the ones that the PR office picks out and decides are newsworthy, but all the ones that you want to see. If you're at a private institution and you don't have the benefit of using the Public Records Act, you still might not be out of luck. There's at least one state, Georgia, that has a very good state statute that applies to the police departments at private colleges and says those private police departments must obey the Georgia Open Records Act just as public ones must. Even if you don't have an explicit state law, there have been some encouraging rulings by courts and by freedom of information agencies that say if your police department at your private college is doing the work of a public agency, if they're arresting people, if they're shooting people, if they're patrolling off campus, if they look like cops and they act like cops and they smell like cops, then they probably have to disclose like cops. That's true at Yale University. That's been held by their State Freedom of Information Commission, and it might be true at yours. It's worth a try. Does anybody have any questions at this point? Yes.
So what if you're at a campus that doesn't have its own police department? What if you just have a public safety office? Are the rules different?
Well, at a public institution, all public agencies are covered equally by your state law. So it doesn't matter what the agency is labeled, whether it's labeled police or public safety. They still must comply. Same is true under the Cleary Act. Any entity on campus that has the responsibility of responding to complaints of crime, no matter what it's labeled, no matter what it's called, is subject to the disclosure requirements of the Cleary Act. So don't let the campus tell you, we don't have police, we just have security. Doesn't matter for purposes of Cleary Act disclosure. If you are at a campus that has only a public safety or security and not a police agency, then remember that it will probably be the city or the county police that actually come onto campus to make arrests. Those are public agencies, and so even at a private college, you have access to their records, and make sure you know how to use them, build some relationships, build some contacts, and take advantage of that backdoor way to get at the crime that you may not be able to get at through your private college directly. Let's get one thing very clear. If your college is telling you that they can't give out information about crimes committed by students because of federal privacy law, that's wrong. It's widely misunderstood. It is a myth that federal student privacy law applies to crime reports. It does not. There is a federal privacy law called FERPA. It's the Family Educational Rights and Privacy Act. Everybody is familiar with this, hopefully, because at the start of every school year, you got a FERPA opt-in, opt-out form about your school's directory. Everybody has seen that. Here is what FERPA says. FERPA says that any institution that takes federal education money, public or private, has a duty to maintain and enforce the confidentiality of education records, and that's the term, education records. Well, there are times when colleges, frankly, will take advantage of FERPA to deny legitimate requests for public information that have nothing to do with education. The complimentary football tickets that are given out at football games, those have been classified wrongly as FERPA information, for example. If you get FERPed, if your public records request is denied on the basis of FERPA, push back, because the courts have been very practical and common sense in their application of FERPA. The courts have given a very limited application to what is and is not a FERPA education record, and it's got to be something that directly applies to the student's status as a student and to their education, not just anything that tangentially touches on or mentions a student, and certainly not police and criminal records. Congress went back in 1992 and explicitly amended FERPA to say that records kept by police and public safety agencies for law enforcement purposes are not education records. And so if your police department is withholding their reports, or they're giving them to you with all the student names blacked out on the grounds of FERPA, they're mistaken. That's not the law. FERPA is not an excuse for keeping those records confidential. Even when you get information from your police department, even when you get those clery statistics, that ought to be the start of your reporting and not the end. Because, sad to say, statistics can sometimes lie. They can sometimes be incomplete. They can sometimes be deceptive. We've seen this at a number of colleges where those clery reports don't portray an accurate and complete picture of the scope of crime on campus. I want to share with you an example of this at a Texas college where some curious and enterprising student journalists managed to find the real story behind their college's Clery Act reports.
Something wasn't adding up. Student reporters at Texas Tarleton State University knew that their campus seemed safe, but not this safe. Every year, for 5 years in a row, the university reported 0 forcible sexual assaults on its federal crime disclosure report. 0, 0, 0, 0, 0. Reporters for Tarleton State's newspaper, the JTAC, decided the numbers looked too good to be true. The reporters started digging. They filed requests under the Texas Public Information Act for all of the incident reports on file with campus police during the last 5 years. They dug through 1,900 pages of police reports. Then they started counting. What they found amazed them. 10 sex offenses and 35 burglaries were reported to the college's police department, but never made it onto the annual crime report that all colleges are required to publish. The students confronted Tarleton State administrators to see if there might be a legitimate explanation for the discrepancy. There wasn't. The school had simply failed to make its federally required disclosures. the university launched an internal investigation and changed its reporting policies. When the story broke, the U.S. Department of Education got involved. The DOE concluded that Tarleton violated the Federal Clery Act by understating its crime statistics and fined the university $137,000, one of the largest Clery fines in history.
What happened at Tarleton State is an example of how figures can lie. When you get statistics that don't look right to you, whether it's about crime, whether it's about enrollment, whether it's about test scores, whether it's about any kind of trend or pattern, if the numbers look too good to be true, they probably are. And it's time to start digging and asking questions and finding out why. Sometimes what you find out is that the records are deceptive because they've changed the method of record keeping. They've redefined the categories, and so you're comparing apples to oranges. That's important to know. Don't want your story to be misleading. Don't want your story to be wrong. Sometimes you find out that the records are intentionally misleading or are being carelessly kept in a way that portrays an incomplete and a deceptive picture. And that's your job as a journalist to give the complete story. Now, besides the state FOI laws and the Clery Act, there are many, many federal laws that entitle you to specific types of information from your campus. And we're not going to do an exhaustive survey of all of those here because they're all available on the www.splc.org website. Just going to hit a few highlights to kind of whet your appetite. One of these federal laws is called the Student Right to Know Act. The Right to Know Act is one of these laws that's going to help you get inside information even about private colleges, because it applies equally to any college that takes federal money. The Right to Know Act gives you two sets of information that your college must make available. The first is anything to do with financial aid policies. Who is getting it? How much? Under what conditions? And how are they doing about paying it back? How much debt are they carrying? So a snapshot, a portrayal of the financial aid policies and practices at your school. All public information, even at a private institution. The second has to do with athletic scholarships. How are athletic scholarships being administered and given out, and are there differences between the policies for athletic aid and for other student aid? Again, even at a private institution, public information, public record, they have to disclose that information, as well as the academic progress of athletes, so that you can track graduation rates, you can track the academic performance of athletes against the rest of the student body. A lot of that stuff is available online now at the ed.gov website, the U.S. Department of Education website, which will enable you to run some comparisons between your school and other schools. Another one of these specialized laws is called the Equity in Athletics Disclosure Act. Again, this is public information even at a private college. It can be a jackpot of information about basically anything that is being spent on athletics in your school. Facilities, scholarships, anything. And how much revenue is made off of those sports. You may be surprised, despite your perception, about how much money your school is not making off of athletics. The perception is that those programs are very profitable. The reality can be quite different. There are dozens and dozens of these pocket FOI laws, as they're called. And this is just a little sampling of what is out there if you get to know your legal rights and get to know what's available to you. There's one type of public record that absolutely every student journalist should know how to use and should take out for a spin and try out, because you can get some pretty cool stuff. This is the requirement that every institution that is a nonprofit institution, which includes almost certainly your private college, file every year with the IRS something called a Form 990 tax return. The IRS Form 990 typically comes out in the summer and typically applies to the previous tax year. It is a financial gold mine of information about that institution that you wouldn't otherwise be able to get under a Public Records Act. For example, at a private college, you can tell how much money did they take in, how much money did they spend, how much money is in their endowment, how much do they have invested, what are they paying their top salaried executives. Do they have any business deals between the college and the members of their board of trustees? Maybe the trustees are selling them cars or legal services or accounting services. All of that must be disclosed, and those IRS Form 990s are a public document available to you on request, or they're available online through an organization called guidestar.org that's searchable by the name of the institution. And remember, this applies to all nonprofit organizations, so this, even at a public institution, may open the doors to the athletic association, the alumni association, the foundation, the teaching hospital. Anything that's set up as a private nonprofit corporation must disclose. The Form 990 can be a window inside of foundations, which over the years have been the source of some pretty outlandish stories of luxurious spending that's not part of the state budget. Things like luxury cars and luxury travel for VIPs at the university that doesn't show up in the university's budget. So every newsroom should always make it an annual practice to pull and examine these IRS Form 990 reports. It's almost impossible to read one without getting a story. So I want to go back for just a second to what we started out with the hypothetical about that tip that your foundation is missing some money, okay? Well, we know that most foundations are set up as private nonprofit corporations. They may or may not be subject to your State Public Records Act. There's some court cases going both ways. There are some courts that have said that as long as that foundation is doing government business, you can hit them with a public records request just like they were the university itself. There are others that go the other way. So you may not be able to count on going through the front door. You may have to go through the back door or go through the side door. This is where it pays to know the structure of government agencies, right? Because there are many, many government actors that may come into play when money is missing. And those government actors are subject to a Freedom of Information request. So think about that. Board of Regents, Board of Trustees, police departments, public safety departments. There may even be audits that have been presented to the university itself. And once the university has the document and is using it, it's yours. Now it's a public document. So don't always take that locked front door as the end of your reporting. There's almost always a side door or a window where you can get at the information you want. Let's just take a couple minutes to talk about open meetings laws as well. Open meetings laws vary by state, but typically they work this way. If there's a meeting of a board, a committee, a group, something that is somewhere in the chain of a decision-making process of a government agency, even if it's advisory, even if it's a subcommittee, as long as it's a body that's created by law or by appointment that meets and has some kind of an existence, those are meetings that you as a member of the public are entitled to attend. They're meetings where certain record-keeping formalities and notice formalities have to be observed. Open meetings laws typically require a few basic boilerplate things. First of all, the meeting has to be adequately noticed. The public has to know when, where, and what is going on at the meeting. There has to be a record taken of the topics discussed and the votes that are taken. And votes have to be taken in public and on the record. They may be able to close the meeting for discussion purposes, but those votes should be done in an open session where you can see them on the record. The second principle is that a meeting can mean something more than that big committee meeting where everybody sits around the dais. It can also mean the retreat, the study session, any meeting where more than half of the body gets together. And sometimes, depending on the state, 2 members will do it. Sometimes it just takes 2 members of the body to get together, and that's a meeting. And now, meeting can have a very different understanding, right? A meeting could be an audio conference. A meeting could be a video conference. Anytime members of that decision-making body or that advisory body are getting together to discuss the public's business, that's a meeting that you're entitled to attend. Anybody have any questions there? Yeah, go ahead.
So what do I do if I'm at a meeting and I'm pretty sure I have the right to be there, but when I walk in, they tell me that reporters must leave the room. What do I do then?
Well, first thing to remember, let's face it, most journalists don't spend a lot of time in the gym, and so the security guard's going to be bigger than you. Chances are. You don't ever want to get into a direct physical confrontation with security where you refuse to leave. You want to be polite, you want to be professional. Sometimes it's a good idea, stand up and make your presence known and say, I would like a brief recess while we all consult our legal counsel about the legality of closing this meeting, and you can request that the vote to close the meeting be held on the record so that people have to man up and step up and take responsibility for kicking the public out of the meeting, because they may not want to do that. Also, you want to get an idea of whether people other than journalists are being allowed to stay in the meeting. As a journalist, you don't have any superior rights to members of the general public, but you certainly don't have inferior rights. If the committee says all journalists get out, but they let the lobbyists stay in, that's an illegally closed meeting, because journalists can't be selectively disadvantaged and selectively excluded. If that happens to you, get to a lawyer and get to an editor as fast as you can. By way of wrap-up, just remember that these sunshine laws that we're talking about are almost always the floor and not the ceiling. Government agencies can give you documents that they don't absolutely have to, and they will. Government agencies can let you into meetings that they don't absolutely have to open, and they might. If there's a document that you want, try for it, ask for it. Don't assume the answer is going to be no. You go into the president's office, and he's got a memo sitting there on his desk from his legal counsel. It might be that he doesn't have to give it to you, but he can. He's not violating the public records law if he voluntarily gives it to you. So remember, when somebody says, if they try the line on you, I can't give you that document, it's not a public record, what they really mean is, no, you won't give me that document. No, not just you can't. Not you can't give you the document, you won't give me the document. Remember, it never hurts to try. It never hurts to ask. People will call and ask us, can I get into this meeting? Can I get this document? And the answer is you never know until you try. You might surprise yourself.